Morning. Started. I call this meeting of the Texas Board of Veterinary Medical Examiners to order. It is March 6th, 9:04 a.m. The mission of the Texas Board of Veterinary Medical Examiners is to establish and enforce policies to ensure the best possible quality of veterinary and equine dental provider services for the people of Texas. Mrs. Whitehead, would you please call the roll?
Yes, sir. Dr.
Texas Board of
Gola,
Veterinary Medical Examiner, present.
Dr. Kreiner, Dr. Skaggs.
Here.
Sue Allen,
Here.
Mr. Pardue,
Present.
Miss Olivier.
Present.
Mr. President, there is a
Okay.
quorum.
Thank you. We do have one absence. Just let the record reflect that Dr. Lynn Kreiner is not present with us. Okay, moving on to agenda item number 2, consideration and approval of the January 23rd, 2024 minutes. Board members, is there a motion to approve these minutes for the January 23rd board meeting?
So
So
moved.
moved. Second.
Ms. Olivier has moved. Do I have a second?
Second.
And Mr. Pardue has second. Any discussion about the minutes? Okay, hearing none, all those in favor, please say aye.
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 Opposed, same sign. Okay, the motion carries. The minutes are approved from January 23rd, 2024. Moving on to agenda item number 3, public comments. We welcome public comments today, but I must advise anyone speaking public comments that we cannot hear any public comments regarding to any case that is yet to be finalized. So please be advised, comments must be limited to about 3 minutes. Do we have any public comments to be made today? Please come forward. Good morning.
Good morning.
Please state your name for me.
Good morning. My name is Heather Kativa. Thank you for the opportunity to approach the board, those here and virtually. Today, I would like to speak about a proposal for a future agenda item for consideration. I'm happy to speak at whatever interval is appropriate to members of either the commission or the state board, agency itself, and or committees. What I am asking for is that on a future, at the next or a future, near future meeting, is that ORD 683 be placed on the agenda for discussion, which would include historical, agency, and legislative aspects, application, previous and potential future. The significance of this ORD in the complaint process, and possible rule considerations going forward. And that is my request.
Okay.
Thank you.
Thank you very much for your comments and being here today. Staff, do we have anybody virtually that is signed on for public comment?
No, sir.
Any other people in the room for public comment? Okay, hearing none. We're going to move on to our next agenda item. Agenda item 4 is consideration and possible recommendation to the Texas Commission of Licensing and Regulation regarding contested cases heard before the State Office of Administrative Hearings. If anyone is appearing in person today to discuss these cases, we will call you up to address the board. The prosecuting attorney will have the opportunity to be heard first, and then the respondent. Please make sure you state your name clearly and who you represent. Each side will have up to 5 minutes to speak initially, and then up 3 minutes for a rebuttal if necessary. Please understand the board can only consider information that was in the record at the time the case was presented at SOA. Please limit your comments to what is in the SOA record. Oh, okay. All right. We're gonna adapt and make a down to a different agenda item before we do that. I've been asked to do this. We're gonna go ahead and move into executive session prior to this. So my apologies for announcing that. Pursuant to Chapter 551.0171, 1 and 2 of the Texas Government Code, this meeting of the Texas Board of Veterinary Medical Examiners will now go into executive session. It's 10:12 a.m. and pursuant to sections 551.01711 and 2 of the Texas Government Code, the board has returned from executive session. No action was taken in executive session, so we will move back to agenda item 4. Is consideration and possible recommendations to the Texas Commission of Licensing and Regulation regarding contested cases heard before the State Office of Administrative Hearings. If anyone is appearing in person today to discuss these cases, we will call you up to address the board. Prosecuting attorney will have the opportunity to be heard first, and then the respondent. Please make sure to state your name clearly and who you represent. Each side will have up to 5 minutes to speak initially, and then up to 3 minutes for rebuttal if needed. Please understand the board can only consider information that was in the record at the time the case was presented at SOA. Please limit your comments to what is in the SOA record. We will begin with item number 1, which is Mark Lee and Dr. Cody Kothman. So first up, Mr. Lee.
Morning, board members.
Good morning.
Ms. Nicola. This case is about two complaints that were filed against the respondent. They were tried together for efficiency. Both complaints involved some record-keeping deficiencies. One was alleged to have a standard of care violation, and the other was alleged to have a failure to refer violation. Dr. Kothman had 2 prior orders with record-keeping and standard of care violations. The board attempted alternative dispute resolution as directed in the rules, but they could not resolve the case. The contested case hearing was held at SOA on October 24th, 2023. The ALJ issued a proposal for decision on December 11th of 2023. The ALJ found that both cases had record-keeping violations, and the case with a standard of care violation was proven, but that the failure to refer was not. The standard of care violations involved use of general anesthesia and pain management. The ALJ's recommendation in the case was a 1-year probated suspension, continuing education in the areas mentioned in the complaint, monitoring and reporting for 1 year, and a restriction on procedures using general anesthesia or pain management until Dr. Kothman demonstrates proficiency. Both parties filed exceptions. The staff does not agree with all the ALJ's findings as noted in the exceptions, but we do agree the proposed sanctions are appropriate. The ALJ considered all the correct factors, and for the sake of case resolution, the staff recommends adopting the PFD as written. Any other questions?
Any questions, board members? Okay. Hearing none, just for the record, I'd like the record to reflect that I, Steve Gola, am recusing myself from this particular case. Okay, next up, the attorney for Kothman.
Good morning.
Good morning.
I'm David Brown with the law firm of Ewell, Brown, Blank and Knight, here for Dr. Kothman. Some of what I'm going to say is going to cover some of the same ground that Mr. Lee covered. But so the PFD in this case finds 3 separate violations on the part of Dr. Kothman. The first 2 relate to record keeping. For those, Dr. Kothman has already undertaken efforts to correct his systems and practices. In addition, we've obtained clarification from staff on a couple of items, including what's necessary for anesthesia monitoring to be compliant and post-operative medications, and those problems are either fixed or being fixed. The second and most significant of the violations that are assessed under the PFD is with Dr. Kothman's treatment of one animal. The issues came down to preoperative testing, post-operative instructions and medications, and most importantly there, the right of the client to decide which would happen. So Dr. Kothman's clientele in Lubbock are not wealthy people. Dr. Kothman explained that his services are provided on a streamlined basis. They enable his clientele in that part of Lubbock to afford the services they need. As Dr. Kothman described it, and I think the Veterinary Association covers it. It's on a spectrum of care. That is, the idea is to assess what's needed and to give the client the control over what exactly will happen with the animal. Even then, and in the record are Dr. Cothman's bills. They are very low. And even then, they're often refused by his clientele because they just can't afford the services that they might want. Now, the record shows, and there's just one dog in issue here, Paco, was noted to have a growth to be removed in the records back in August of 2019. He was quoted $225 for that surgery, or the client was quoted $225 for that surgery and refused it because of cost. 2 years later, after multiple visits with Dr. Copeman for other issues, the growth had been substantially increased in size. And at that point, the dog was chewing on it, it was bleeding. The client was quoted $375 to remove it. The client agreed and the surgery proceeded. No preoperative testing was done, even though the dog was 13 years old. But the only testimony in the record on that issue is that of Dr. Cothman. So I think it's important to note what that was. Dr. Cothman testified, and this is in the record, I can point you to it, that preoperative testing was discussed with the client before the surgery. The client declined it. The offer of preoperative testing was memorialized thereafter in the consent form preoperatively. Therefore, finding of fact 18 is in conflict with the record. That's the one that says that the client never had the opportunity to decline the service. The client signed the consent form, acknowledging that she had read it and understood it. And granted, it's a consent form and people are under stress, but that's what it says. And people have to be held to what they sign. The consent form says several different things that are pertinent to this case. One of them is that there's an opportunity to obtain outside testing. If it hadn't been discussed, that might not be enough, but it was discussed. And there's no testimony to the contrary, and there's nothing in the record to the contrary. The form warns clients that some post-operative surgical or post-surgical concerns may arise, pain or other issues, and that they may need further attention. That's in the form as well. Dr. Cothman testified that, in addition, that his office's outgoing voicemail tells the client to call him on his cell phone if there's something wrong with the dog. There was an issue with that. The client did not allow the phone to reach that point in the voicemail, so she didn't get the cell phone number and didn't call Dr. Cothman after the surgery to get either pain or other issues attended to after the fact. Now, Dr. Cothman also testified that it was his customary practice to call back the clients the next morning to discuss how the surgery had gone and how the client's animal was handling the postoperative condition. There's nothing to dispute any of the testimony, or there's nothing in the record that disputes or contradicts anything that I've just laid out in the way of how things in Dr. Cothman's practice works. These are the practices of an average veterinarian in the community in which Dr. Cothman practices. It might not be what you find in suburban San Antonio or Dallas or Fort Worth, but it is what you find in that part of Lubbock every day. The services that Dr. Cothman provides were performed competently at the prices that were offered with the conditions that were faced in that community. Now, we've owned dogs, my family has owned dogs my whole life. And we have taken them in for procedures and surgeries over the years because dogs do what dogs do. And I couldn't get into the door of any of the vet offices that I went into for $300.
Excuse me, sorry, Doug Jennings, General Counsel. If this isn't in the record, I ask that you don't present that. Thank you.
It's argument. It's argument. The point being, the bills that Dr. Cothman wrote, the information that is in the record And you can certainly take notice. This board doesn't even get to make the decision, so it's argument. Clearly, this is a different community than most veterinarians, particularly here, deal with. And the standard of care depends on the community. When you review Dr. Copeland's practices as described in the record, you will find that he met the standard of care for the community in which he works. And your recommendation to the TDLR, the commission, should be to reverse the standard of care violation and to back off on the sanctions that were assessed against Dr. Copeland to those that would be appropriate in a record-keeping violation. I'm happy to answer any questions that you might have.
Board members, do we have any questions for Mr. Brown?
Mr. Brown, this is Dr. Randy Skaggs. Thank you for being here today. Appreciate you taking the time to visit with us. Just a couple of questions. You know, the record issue problems with this doctor have kind of been something that we're wondering why there was no improvement in his record keeping, and is there some reason why is he not able to get the information that's out there that's provided to every veterinarian across the state of Texas to meet those standards, or what's the reasoning as far as you understand it as to why those records are subpar?
Well, I would argue that the record-keeping violations are different than the ones that happened before, and that they are that the records that I've seen are while there are items missing, like for instance, what he had put down about anesthesia was just what happened in the way of the drugs, and that what he needed to do was put in more information than he did. But I would also say that most of the record-keeping violations are, it's a matter of a checklist, right? It's having a checklist, and it's having a list of things that you sign off on that this happened, that happened, the other thing happened. And I think it's mostly about having systems in place to handle it. His practice in Lubbock is for his neighborhood, and granted, he's got to have the records to cover everything that he does appropriately. And he admitted that he had record keeping violations. He said that on the record, but he has undertaken steps to fix it. And from what I've heard about those steps, that's what he's doing.
Okay, thank you. One other question. While I commend anybody for trying to do the best they can and offer low bills. I'm in a very similar situation, if not almost identical to that. But patients, and I'd like you kind of address and see your feelings on this, regardless of the bill that's going to be had at the end. I feel that the patients still expect proper care. While a cheap bill is nice, it doesn't keep you. I mean, when you go to a veterinarian, we as a country and as a person and citizen of the state of Texas should accept a good quality of care. And even though the bill's cheap, we shouldn't expect anything less. We realize that certainly you may not have all the bells and whistles, but the quality of care should be there. So what are your feelings? I mean, what does he
Absolutely agree.
You get the idea that the low bills allow him to not do the things that a standard veterinarian would do?
No, that's not really the point of it. So the question really has to do with two things: preoperative testing and postoperative follow-up and pain care. So talking about the testing first, it's always up to the owner of the animal to decide what's going to happen to that animal, right? It is the owner has control over what testing would be done. And Dr. Copeland testified that he doesn't have in-house testing capacity. He sends people off to do that if they want that kind of service. But preoperative testing, while helpful, is not necessarily something that has to be done if the client doesn't want to do it. And so if the client doesn't want the testing, then the surgeon doesn't have to do it in order to stay within the standard of care. As far as the postoperative care, Dr. Copeland administered a drug that there's obvious disagreement over whether or not it's sufficient. But the idea, post-surgery was to have, and this is disclosed in the consent form, which is in the record, and that, was part of the testimony of Dr. Coben. If the client if the animal is in distress post-operatively, and it was not when it left the facility, it was wagging its tail and walking away. If the animal is in distress post-operatively, in pain or otherwise, then the opportunity is there, not just through the client calling the doctor, but also the doctor calling the client the next day to determine whether or not the animal needs more care or more medicine, whatever it might be. So things aren't dispensed perhaps because of cost, but that's because the client's decision is, I can only spend this on the surgery. And, you know, there can be a debate over whether a 13-year-old Chihuahua would have benefited, or whether the surgeon would have benefited from knowing more about the condition of that animal going into surgery. But would it have made a difference in what the doctor had done? I mean, the tumor was external, bleeding, and the dog was quite literally consuming it. And at that point, the surgery needed to be done. The testing, because it wasn't done on site, couldn't have been, and this is all in the record, could not have been done quickly enough to have abated that emergency. And so we're in a situation where the surgery was done. Would everybody have benefited from knowing that perhaps the dog had some liver issue or something else going on? Maybe, because maybe the decision would have been euthanasia instead of surgery. But when the client is offered testing and declines it, that's the end of that discussion from a standard of care issue.
Okay, thank you very much.
Council, I just have a couple questions, and we'll pose them, generally speaking, in a similar way that Dr. Skaggs did. I personally live in Lubbock. I know where this is located, and I'm struggling as a board member to adjust with the argument of standard of care. Lubbock is a town of 300,000 people. Within a mile to a quarter-mile section of where this practice is located is higher than average medium homes, multiple subdivisions with moderate to higher end homes. I understand, and I see here he's in an area of town where, yes, it's growing around him, and it was more rural at one point. But Lubbock also has 40 plus veterinarians. I don't know the number, but I know we have a huge veterinarian community. And so I'm really struggling with the argument on the standard of care. So can you kind of just break that down for me a little bit? That I challenge that, and I'd like to hear your response on why the standard of care is that being discussed like it's post Texas or Hereford, Texas versus Lubbock, which is a strong city with, to me, it's a higher level of care.
Right. And so I'm not arguing that there aren't other clinics that the dog could be taken to that would have provided different care. They might have on-site testing. They might have on-site imaging. They might have things of that nature in that practice. But this client declined a surgery because it cost $225 the first time. This client, I think rather obviously, wasn't going to go to a clinic where it was going to cost $300 for testing and $300 for imaging before doing a $500 or $1,000 surgery. So by community, I think you're going to have to break this down into not just communities geographically, but also communities as to who visits what vet. Because there are discount clinics. Some people take their dogs to get their rabies shot at Tractor Supply because it only costs them X dollars to do that. People choose what they want. And here again, setting aside whether the standard of care ought to vary or not based upon the clientele of a given vet, and I think the evidence is that it should, but if you want to set that aside, in the end, the client gets to decide what is done. And if the client declines the testing, that's the end of the discussion. Now, Dr. Copeland could have refused to do the surgery without testing, but as the record reflects, it was an emergent situation anyway, or was getting that way. And the testing in the end, there's no evidence in the record that the testing would have made any difference in the outcome. The same is true for the post-operative care. There's a dispute over whether or not post-operative care instructions were given to the witness or to the client, but they were in the form the client signed, and the client wasn't there to testify that she didn't get a copy of the form. What Dr. Copeland testified was that it is their standard practice to give a copy of the form to their clients. And the clients sign it saying and acknowledging that they've read it. At some point, that becomes a client responsibility, not a standard of care issue. So I think I've addressed your question. That it has to do is that the locale has as much to do with the economics of the clientele as it does. You're right, Lubbock's way different than it was even 5 or 10 years ago, much less, further back than that. And I am confident that different vet clinics attract different clientele. And the reason is because of cost and the decisions of the clientele on what treatment will be.
Thank you. I have no further questions.
Fellow board members, any other questions for Mr. Brown? Okay, hearing none, Mr. Lee, do you have any rebuttal? Briefly.
Yes, sir. Board members, with respect to the record keeping on page 16 of the PFD, the ALJ discussed that. And in part, what he found was that the record keeping wasn't sufficient to document the differential diagnosis and the details necessary to substantiate the treatment. And it's important to remember, although we don't know what the cause was, Paco, dog number 2, died less than 24 hours after Dr. Copeland performed this surgery. The record keeping the failure to adequately document in part prevented the determination of what the cause of death was. And with regard to the form, the ALJ found that a standard form does not relieve a professional obligation to adequately inform each client regarding each specific patient.
Board members, do you all have any questions for Mr. Lee? Okay, Mr. Lee. Thank you very much. Mr. Brown, do you have any rebuttal to his rebuttal?
No, Your Honor.
Thank you both, gentlemen, for your testimony and words today. Much appreciated. Okay, with that, is there a motion from the board on this matter?
Dr. Gold, I move to adopt the PFD as written with changes to the conclusion of Law 15. I recommend that changing conclusion of Law 15 to include the following sanction: 1 year probated suspension, 6 hours of continuing education for record keeping, 6 hours of continuing education for anesthesia, and 6 hours of continuing education for pain management. Also, would like to state he may not perform surgical procedures requiring anesthesia for 3 months. During the term, he must also submit quarterly reports certifying compliance with the terms of the probation and include sample records for 10 cases each quarter for review.
Okay, I have a motion as read by Dr. Skaggs. Do I have a second?
Second.
Been seconded. The item presented to us in the form of a motion is now open for discussion. Board members, do y'all have any discussion? Okay. Hearing no
Sorry,
discussion.
Dr. Skag or Dr. Gola, I appreciate the time today. And looking at the record, a firm believer that standard of care doesn't change depending upon the person. That sticking within this record, this is a good motion. Thank you.
Thank you, Ms. Whitehead. Any other discussions? Okay, hearing none, we're going to go ahead and call the vote on the motion. Dr. Skaggs, will you just read the motion for the record one more
Yes.
time before we vote?
All right. I move to adopt the PFD as written with changes to conclusion of law 15. I recommend changing conclusion of law 15 to include the following sanctions: 1 year probated suspension, 6 hours of continuing education regarding record keeping, 6 hours of CE regarding anesthesia, and 6 hours of CE regarding pain management. It may not perform surgical procedures requiring anesthesia for 3 months. During the term, he must submit quarterly reports certifying compliance with the terms of the probation and include sample medical records for 10 cases each quarter for review.
Okay, we will now vote on that red motion. All in favor, please say aye.
Aye.
Any opposed? Same sign. Okay, motion carries. Thank you very much. Okay, moving on to our next case in front of us today. We'll follow the same procedures. And we will start with the Ashley Watts case in front of us. I'm going to ask Mr. Lee to please come and present his case.
Thank you, Dr. Gold. And I'm sorry for those of you who don't recognize me. My name is Mark Lee. I'm the staff attorney for the board. All right, this case involved a large horse named Allie that was taken to Texas A&M for a badly infected leg. The respondent was a clinician who performed surgery on the leg and was responsible for post-surgical care and treatment of the horse. The complaint alleged that the respondent failed to meet standard of care, performed unnecessary and unauthorized treatment, engaged in illegal animal cruelty by using a cattle prod to repeatedly shock Allie in an effort to get her to stand, and that she failed to keep adequate and truthful records. Now, all of these were related to the post-surgical care, not the surgery itself. A contested case hearing was held at SOA from February 7th through 9th, 2023, in front of 2 administrative law judges who cooperated on the case. Staff submitted testimony of 10 witnesses and 8 exhibits, including a video which did not have audio, which depicted the use of the cattle prod. The respondent submitted the testimony of 3 witnesses and 3 exhibits. Testimony included 5 veterinarian experts who were not involved in the actual care of Allie. The ALJs issued a 152-page proposal for decision on August 22nd, 2023. The exceptions did not result in any change to the PFD. The ALJs found that the staff had proved all the allegations in the complaint. In the PFD, the ALJs went through the testimony of each witness individually and in detail and included reasons why they found each witness credible or not. They also segregated use of the cattle prod according to when it was used, where it was used on Allie, and as well as use of the sling and how that affected the respondent's actions. In other words, there was extensive analysis of the evidence that was documented in the PFD. The ALJs found that respondents' use of the cattle prod on Allie for almost a half an hour and the use of it on sensitive places on Allie was animal cruelty. They also found that respondents' use of the cattle prod was not adequately documented in the patient records and that those omissions were deliberate and dishonest. The violations were each Class A, and the ALJs analyzed the appropriate aggravating and mitigating factors. The ALJs recommended a 5-year suspension with 2 years active, a restriction on her practice requiring supervision for the remaining 3 years. They also recommended continuing education in the areas of record keeping, professional accountability, leadership, and or other topics the board deems appropriate. Finally, they recommended imposition of a $15,000 administrative penalty, and the staff recommends adopting the PFD as written.
Any questions for Mr. Lee? Okay, Mr. Lee, thank you very much. Next, I would ask representation from Mrs. Watts or Mrs. Watts herself, please come forward.
It's Dr. Watts.
Dr. Watts.
I appreciate you giving her proper title as due, sir. You've once more demonstrated your prejudice and bias against her. Thank you for doing it on the record here. As you know, I filed a motion to recuse all of the board members, primarily because of your actions in allowing Ms. Katiba to come in here at this last board meeting and testify to things regarding this case and the case that Ms. Katiba complained about.
Excuse me, counsel. Doug Jennings, General Counsel for TDLR and the Commission of Licensing and Regulation. Could you explain maybe the substance of that motion? We did not receive a copy.
I
Nor
sent
did
it
the
to
board.
Brittany. Did you not get it?
No.
So it was not before the board today because we were not
Okay.
properly served. So
have
I would
an
ask
extra
that
copy.
unless we have proof of proper service, we would not discuss this.
Well, I filed it with the ALJ through the SOLA system.
Okay.
And
Thank you.
so Mr. Bergman's got a copy, who was the prosecuting attorney, which is who I understood was going to be here today, was the prosecuting attorney. Shirley didn't have anything to do with the case.
Dr. Gola, if you don't mind, I'd like to maybe retire into executive session so I can look at this motion and properly advise the board.
I have no objection to that.
Okay, pursuant to chapter 551.01711 of the Texas Government Code, this meeting of the Texas Board of Veterinary Medical Examiners will now go into executive session. It is 10:45 a.m. 11:07 a.m. pursuant to sections 551.01711 of the Texas Government Code. The board has returned from executive session. No action was taken in executive session, so we will move back to our agenda item 4.
Dr. Gola, Doug Jennings, General Counsel, just want to correct the records, 551.071, subsection 1, Government Code.
I'm sorry, 551.071.
Yes, thank you.
Thank you. No action was taken in executive session. We will move back to our agenda item 4 with the case with Dr. Ashley Watts. Dr. Farrell, you may proceed.
Thank you. So first, I have a motion to recuse board members in this case because of Dr. Gola's actions in inviting and allowing and even contending that it was Ms. Katiba's absolute right to testify about this matter and a companion matter at the last board meeting over objection. Not only did Ms. Katiba not have the right to do that, Dr. Watts had the right to not have that happen. She also had the right to confront that witness and cross-examine her if she was going to be here and testify, which was completely improper. It's information that this board was not to consider because it was not presented at the board hearing. Your counsel over here has been objecting to those things already that weren't heard at SOA, and so they shouldn't be brought up here. And that's exactly why she should not have been here. So I think it shows bias that you would allow her to do that and contend she has a right, and at the same time, just trample on Dr. Watts' rights, even though she's a member of the public as well, and her rights should be protected by this board, but they were not. They were completely denied in this instance. You in particular, Dr. Gola, you and I have had conversations about this case prior to your appointment to this board. You told me about things you had heard from others about Dr. Watts's character and actions at the school. And so I believe that you have.
Is that on the record of the case? Because I think we're supposed to stick to what is the.
Dr. Gola, you've already allowed things that weren't at the hearing to be brought into this matter. So I don't know that.
Counsel, that's no basis to continue doing so. So the board is aware of the motion, and we are ready to proceed with the merits of your case. If you choose to spend your time discussing the motion, that's fine. Keep in mind that, you know, we do not have an infinite supply of time, and we would prefer to talk about the merits of the case as that motion is not properly before the board.
Well, it is before the board. And you know, Dr. Gola, that happened, and I know it happened, and you can try to deny it, but it also shows that you had a bias against her before even getting on this board. This board has engaged in disclosing confidential information. I do believe, and I have information to believe, that this board presented confidential information to a Brazos County grand jury.
Again,
And-
this Doug Jennings, General Counsel, this is not properly before the board. Motion has been filed with SOA. There has been no hearing or decision on that motion. Therefore, this is outside the administrative record. Please confine your comments to the substance of the case that appeared before SOA, not in this late motion.
So this shows the bias, this governing body that's supposed to make this decision today. And so I'm pointing it out, and it's completely improper. And in fact, it was official misconduct, if that did occur, for any staff or board member to present any of this information to a Brazos County, Texas grand jury. Likewise, it was improper to not file this under seal, as is allowed at SOA, because it introduced all of this to the public, which is more evidence of this board's disregard for Dr. Watts' rights. This decision being made now is improper because it was not it's not being done timely. It's 8.5 months after the record closed in this case. And it's way more than 60 days, which is your statutory deadline. This board also issued an emergency suspension against Dr. Watts, which required somebody from the board to determine that there was an imminent danger. And then there had to be a hearing within 14 days after that to make that determination where Dr. Watts could be there to respond. The hearing was scheduled. I do recall Mr. Pardue was at the hearing. I don't recall who else, but not one single piece of evidence was introduced in support of the temporary suspension, which makes me think that there never was any evidence or it would have been submitted that day. So the temporary suspension was dismissed after Dr. Watts had to go to the expense of defending it. Likewise, any member of the board who was involved in the informal conference should not be participating in this matter. In this case, the board presented numerous quote unquote experts. They were not qualified as experts. Experts need to be qualified upon the subject matter. They can't just say they're an expert. They can't just come up with some standard of care. It has to be some recognized standard of care. In this case, everyone admitted, every expert admitted that there was no recognized standard of care. I don't know what the ALJ's problem was, whether it was a bias problem or just didn't like the video that she watched, but she recused someone who was an expert, who actually had been trained in the use of the hot shot, who actually was present at this time, and who was board certified surgeon. And the reason they recused her was because that she did not know she had been designated as an expert. That is not a test anywhere in any case law or in any rule that would disqualify an expert. So for her to be disqualified is completely improper. For these other supposed experts, one's a shelter veterinarian who has seen a hot shot used twice in his life, once when Dr. Watts used it and once when another veterinarian used it and touched a horse once and it jumped up. All of your experts admitted they don't know what the standard is. Dr. Dutton says, I was never taught the standard. Dr. Dutton says, I have never taught the standard, but here's what it is. It's 5 or 6 hot shots. That's just his ipse dixit. He's not giving you any recognized standard. So when there is no standard, the treatment is left up to the discretion of the surgeon. Mr. Villarreal, who was never designated as an expert, was allowed to testify as an expert because he said he's an expert during trial. Completely improper. And when he was asked a question by Dr. Watts, he testified that he did not respond to her. And the ALJ assumes that's because she wouldn't have answered him or done what he asked. No evidence of that, just something the ALJ made up in her head. Ms. Baker, who was a technician who was not present, was allowed to testify to things that she had no knowledge of. She was not credible. Specifically, she was trying to testify that she was trying to get Dr. Watts to do something else with the horse, move it to a different stall. Then later testified that The reason she didn't talk to Dr. Watts about something else was because they're not allowed to talk to the surgeons unless they're specifically asked. And she couldn't explain why she was talking to Dr. Watts if that was the rule that she always followed. Dr. Doring, who was the expert who was told she was not an expert but was allowed to testify as a witness, did witness everything, thought it was appropriate, could explain why she thought it was appropriate, and didn't know she'd been designated as an expert, as if anybody who's not an attorney would even know what that means to begin with, and why it would matter, I don't know. If you're qualified, you're qualified, and you should be allowed to testify. Again, she's a board certified veterinary surgeon, was a resident at the time, and observed everything, has seen hot shots used on many occasions on horses to good effect, and knew that Dr. Watts likewise used it on a rare occasion, always to good effect. And this was the only time that it did not result in the horse getting up. And we found out at necropsy why that was. The horse had some internal derangements that did not show up on any of the blood work. Mr. Barry, the owner of the horse, his testimony was not credible. He testified that he didn't know about this. He did know about this. He never complained about this. He testified on direct and volunteered that he didn't know about it and volunteered, and I've got no reason to lie. If anybody tells me they got no reason to lie and volunteers it like that, where they haven't been cross-examined or accused of lying, they're lying. I got him on cross-examination, and I asked him, I said, you know, you've got a high-level position with the Houston mayor's office, don't you? Yes, sir. And I said, it's kind of a visible position to the public, isn't it, sir? Yes. And if the mayor found out that you had authorized what was shown on that video, you would probably lose your job, wouldn't you? Yes, sir. And that would make it very hard for you to support your family and the manner to which they become accustomed, wouldn't it? Yes, sir. So you do have a reason to lie, don't you? Well, yeah, I guess I do. So on cross-examination, he admits he's got a reason to lie, and there's a reason he lied. And they make a big deal saying that Dr. Watts didn't put the use of the hot shot in the medical record. It's in the medical record. Look at the medical record. I beg you to look at the medical record. For some reason, the ALJ wants to say that if it's not in some part of the medical record besides the communications, then it's not in the medical record. But the communications are a part of the medical record. When you ask A&M for that medical record, you get the communications. They are part of the medical record, and that's in there. So that's bogus for them to even try to say that she didn't include it in the medical record or that she was trying to hide it for some reason. She was not. She addressed it head on. She, within a week, was being investigated at Texas A&M by Dr. Eads and Dr. Watkins and Dr. Keith Chafin, all very well respected doctors at Texas A&M. And they all determined that she was not at fault, should not lose her job, and that she was doing the best she could to save the horse that was going to die otherwise. If it didn't get up, that horse was going to die, and it did die. While she was waiting for Mr. Barry to get back to her and let her know if he would let her stop, although she had actually told him she was not going to do anymore because she didn't think it was going to be effective. To say this is some kind of a revocable offense is absurd. Dr. Watts hasn't practiced in the last 2.5 years other than to pull and run Coggins on her own horses and write health certificates for her own horses. Once she knew this board didn't want that to happen, she stopped doing it. And it wasn't like she was doing it daily or weekly or monthly. There were, I think, 4 instances in her career where she had used a hot shot on a horse. So just completely out of line to even suggest this a revocable offense. I've seen similar cases where the board says dismissed due to voluntary compliance. Seen cases where people wrongfully euthanize somebody's dog. They got an informal reprimand. Client said, don't euthanize. Veterinarian goes in the back, euthanizes it, comes back and says, oh, it died. Informal reprimand.
Don, out of respect for you, I'm giving you over 15 minutes. Our rules say 5. I'm going to give you time, but if you could please get us to it.
Yeah, we're talking about a 150-page proposal for decision, Dr. Gola. If y'all really want to hear about it, great. If it's like I think that y'all have just got a bias against her and are going to rule against her, then I understand. If you
Again,
don't want
I'm
to hear
giving you
about
time. I'm just asking you that we do have a limit.
it. Again, Dr. Dutton was not credible. He just makes up a standard. Dr. Buchanan, Ben Buchanan, says he's never seen a hot shot used on a horse in his life and doesn't think it should ever be used. So even your own experts can't agree on a standard of care. I question whether or not Ben Buchanan's being truthful when he says he's never seen a hot shot used on a horse. I know his father. Dr. Eads, again, she claims that she recommended that, and I don't even recall all the details of it, but she and Dr. Watkins and Dr. Chafin did recommend some remediation with Dr. Watts. They sent that email to Dr. Green, who was the dean of the school, who reported back to them in a very short response. That's fair. Dr. Eads says that later she was told not to follow through with the remediation. Dr. Eads continued to give Dr. Watts merit raises, and the school continued to employ her. And like I told Dr. Eads, if it ain't in the record, it didn't happen. So she couldn't point us to anything in the record that said that Dr. Green told her not to follow through with what she had recommended. And Dr. Green testified that she never said that and wouldn't have said that, and that she was not going to walk on top of the people she had delegated the investigation to. Dr. Green, again, expert, been in the horse business for a long time, been in a lot of universities, seen a lot of care by surgeons, says she's seen the hot shot used and doesn't have a problem with it, and didn't have a problem with this situation. So the only reason she said it's fair is because she wasn't going to intervene. She wasn't going to try to tell them not to do anything if that's what they wanted to do. Dr. Foland, another good expert. Dr. Dutton and Dr. Buchanan both agree that he's a reasonable veterinarian, and that if they disagree with him on a subject, then it's something upon which reasonable minds can disagree. They disagree with some of what he says, but not all of what he says. So clearly, Dr. Foland's opinions are matters upon which reasonable experts can disagree, which means that there is no violation of the standard of care. As to the treatment being unnecessary, the only way to find out is to keep trying. If the horse gets up, then it was necessary. If it doesn't, then you can argue it's unnecessary. But I'm sure that the same kinds of things went on back when people first started trying to repair lower limb fractures in horses. I'm sure that a lot of people got accused of doing cruel things to horses because they were putting them through pain and surgery and additional fractures as they would try to get up until they perfected a lot of these techniques. But that doesn't mean we don't try to perfect these techniques. And like Dr. Green points out, there have been other areas of practice where Dr. Watts was criticized by her peers about her treatment for, and named specifically 2 other horses. And thankfully, Dr. Watts disregarded the criticism and stuck with it. Much like when thalidomide was being pushed on the United States, and everybody, drug manufacturer, everybody at the DEA was saying, oh yeah, it's safe, it's safe, it's safe. Let's just give it to pregnant women all day long.
Tom, we don't, that's not part of this case, so let's leave it.
That's argument.
Let's leave it.
It's argument. Okay.
Thalidomide has no bearing on this case. Please proceed.
The story has a bearing on the case
Thank you.
and it's argument.
Please proceed.
Thank you. I would like to proceed without interruption. But anyway, there was one holdout, young lady who was the head of the DEA at the time. And she said, no, there's just not enough evidence yet. She didn't say it's not safe. She said, not enough evidence. And sure enough, she was right. And thankfully, she stood up to the people trying to bully her into abandoning what she knew was right, just as Dr. Watts did. Again, Dr. Watts did acknowledge in her records this treatment. Please look at the record. You've got it, look at it. There's been no evidence of her intent as far as the criminal matter in order to prove a violation of a criminal law. Even if you're just doing it at a lower standard, preponderance of the evidence, you still have to prove intent. No evidence was brought in of her intent, so there is no evidence of any violation of the cruelty statutes. And again, the sanctions are not justified in any regard, even if you think that the treatment was not justified. She's not an imminent threat. She's not somebody that's out there just committing malpractice day after day or is trying to say, well, you should let me keep doing this. She says, I'll never do it again because it's not worth it, even if she thought it would help. She has an impeccable career. She's a very bright surgeon, top of her class at Cornell, and heavily sought after getting her residency completed and getting her diplomat of the American College of Veterinary Surgeons. And so I would recommend that this thing be dismissed due to voluntary compliance at the worst, or just dismissed. And I appreciate your time.
Thank you, Dr. Farrell. Mr. Lee, do you have any rebuttal comments?
Just briefly, sir. Yes, sir. I'd just like to remind the board that 2 administrative law judges collaborated in hearing this case and producing the proposal for decision. That it's the ALJ's function to determine the admissibility of evidence and the expert's qualifications. And as the fact finder, they're the sole judge of a witness's credibility. And finally, even if some of respondents' points are accepted, that there's still sufficient evidence in the record to support the findings and the recommendations in this case.
Board members, do
Thank
you have any questions of Mr. Lee? Mr. Lee, thank you.
Yes, sir.
Dr. Farrell, would you like to make any comments to his rebuttal?
Yeah. So my understanding of why there was 2 ALJs was because one was being trained. And so I'm not sure that 2 is better than 1. And as far as who has the ability to be to judge the credibility of witnesses, this board can do that. This board has done that. In fact, in other cases, if you look at the case of Ron and Sherry Bohannon, this board completely reversed what the ALJ did. The ALJ bought into all of this phony testimony, and and this board said, no, we don't buy that, and they dismissed the case. So don't be fooled. You can do that. And did anyone have any questions for me?
Hearing none, thank you for being here today, representing your client. Okay, board members, do I have a motion in considering this case?
Dr. Gola, based on the nature and the severity of this case, as I review the record, I move to adopt the proposal for decision as written, but I move with the following exceptions. I move to amend conclusion of law 16 to change the sanction to that of full revocation of licensure and a $15,000 administrative penalty.
Okay, I have a motion from Ms. Whitehead. Do I have a second?
Second.
Okay, it's been moved and seconded. It's now open for discussion. Board members, please provide any discussion. Okay, hearing none, we're going to take a vote on the motion as read by Ms. Whitehead. All in favor, please say aye and raise your right hand.
Aye.
Aye.
All opposed, same sign. Okay, motion carries. Ladies and gentlemen, that concludes our business on our agenda today. With that being said, there is no further business to come before the Texas Board of Veterinary Medical Examiners this morning, and this meeting at 11:34 is adjourned.